Hey, good morning, Summerlin. Good morning. How are we doing today? It's a beautiful Wednesday morning, and we're ready to rock and roll. You guys on top of the world?
You got it.
Yep.
You bet.
We're on top of the world. So how's the market out there?
We have 1,987 single-family detached available right now.
How many is that again?
1987.
How about condo townhomes? Total, what's the total number with condo townhomes?
We got 550 condos, 269 townhomes.
Bam. So inventory is tight, folks. Inventory is tight. Can't say enough. If you guys are paying attention at all, everything's about getting listings right now, right? It's like money in the bank, right? If you have a listing, for the most part, it's like taking it, cashing a check. So hopefully you guys are increasing your listing awareness, your listing target marketing, right? And of course, staying in contact with your sphere of influence, your database, to make sure you're educating them on what's going on. A couple of things I've read recently is, and I'm sure you guys are keeping in tune as well, is that that's possible we start seeing a little bump in inventory. I was reading, I believe, a KCM article, Keeping Current Matters, and as the goal of COVID-19, starting to dissipate on some level, hopefully homeowners are a little bit more comfortable getting their homes on the market and having people come through. As we go into the selling season, we're going into spring right now, which we know typically we have an increase in inventory automatically just going into the summer months. So we'll keep our eye on it, of course, but more than ever right now, you guys need to really leverage every vehicle you can marketing wise. If you guys aren't sending out I have a buyer letter, right? I have a buyer looking in your neighborhood. That's important right now. If you guys are working with buyers, what a great way really to start target marketing and get into the neighborhoods that the buyer's looking at and start letting people know that you have a buyer possibly for their home. It's the best way really to really go directly to a homeowner without the fluff, without the the nonsense, to say, listen, I have a buyer looking to buy a home in your community. Are you considering selling, right? Or do you know of somebody that's considering selling? So hopefully you guys are generating those. I know we talk a lot about that. I just don't know that everybody's using those vehicles for that. But let's dive in. I want to be very respectful of our guest speaker's time today. Lee Drizzen was wonderful enough to jump on to talk a little bit today about probate for you folks. And then I'm going to do an overview of the new forms that were launched. One of the more grueling forms is the new smart home device addendum. In fact, I'll let Tim cover that one so he can stumble through that. But no, I'm just kidding. Anyways, it's a little bit of a tasking form. So we'll go through that as well as some of the updates to the RPA, and try to answer any of your guys' questions. Maybe have a little bit of a chat on the forms, your thoughts on them, and go from there. So good morning, Lee. I see Lee's on here. I'm going to look for him to spotlight him real quick. And are you with us, my man?
I am.
Awesome. Good morning.
Good morning, everyone.
All right, there he is, Lee Drizzen. Woohoo!
How you doing? Damon, you have that PowerPoint presentation. Are you running that?
Right there, my man. So let me share my screen, and it's right there.
Okay, perfect. So hi, everyone. Good morning. First of all, I want to just thank Damon, and also give a shout out to Tim, who's always been great about helping us get in touch with Damon and get into the offices. And this is an abbreviated version of a course that we actually have a 3-hour course about everything you want to know about sales in probate and guardianship. And we're breaking this down into 2 1-hour classes that we're submitting. So you're going to get an abbreviated version in the next 20 minutes of what would normally be covered in about an hour. So anyway, Tim, go ahead and, I'm sorry, Damon, go ahead and go to the next slide. So I always start with talking to agents about understanding what is the purpose of probate and understanding how this all works. Because whether you're representing a seller in a probate process, or you may be in a situation where, quite frankly, you're representing an overbidder. We're seeing more overbids in probate than we've seen in a long time. So just having a basic understanding of some of the purpose and the vernacular, I think, is really helpful. And what the whole idea about probate is first of all, to marshal the assets. And that means that the person in charge has to gather all the assets, identify the assets, and a lot of times they just don't even know what they're dealing with. The court then wants to make sure that any creditors that are outstanding of the decedent is the person who passed away, are ultimately going to get paid. And only once all those issues get addressed will ultimately the court approve a distribution to the beneficiaries. Now, during this process, during the probate process, which generally from the time that we open the probate till the time we close it takes no less than 6 to 9 months, one of the advantages we explain to the clients is the ability to sell real property. And what's so important about that is that, and I'm sure that the agents have seen this also, that prices today are higher than they were a year ago. And despite the pandemic, particularly in these probate sales, we have seen the prices continue to escalate. And what's been interesting about that is, from our perspective, was that so many people got nervous about the pandemic and having people come into their home that they pulled their listings. And so there just wasn't inventory. And so it was no real surprise to us that not only did we see prices moving in a good direction, but we also saw the builders building like crazy. In fact, Fox News reported that lumber is actually at the highest that it's ever been in the history of the United States, because all the builders are buying lumber to get more inventory out there. And so what we've told clients is, look, rather than wait to go through the whole probate process, if you've got a piece of real property, now is really the time to strike, because the reality is at some point, the prices are going to start to turn and move downward as more and more inventory becomes available. Damon, go ahead and go to the next slide, please. So understanding certain kinds of assets don't go through probate. So for example, if we had a joint bank account, upon the death of one person, it automatically goes to the other. It's the same thing for joint property or community property with rights of survivorship. Community property, interestingly enough, we see this a lot of times that a husband and wife own property, or two spouses own property as community property, but they didn't put the magic words with rights of survivorship. And what's interesting about that is that while that title community property means that by operation of law, it is to be distributed to the surviving spouse, if it's just titled community property without rights of survivorship, I actually have to go and probate one half of that property. Now, joint bank accounts are a little bit different, and joint tenancies are a little bit different, because as long as either a deed or the bank account uses the word joint, even though it doesn't say with rights of survivorship, it automatically, by operation of law, goes to the surviving joint owner. And so these are kinds of assets that we talk about that are non-probate assets. In other words, they don't have to go through the probate. Beneficiary designations. If I've got an insurance policy, that's a contract between me and the insurance company that says upon my passing, these are where these assets go to this beneficiary. But sometimes we find with insurance policies, one spouse may have designated the other. That spouse predeceased the owner of the policy, and now what happens is they didn't name an alternate beneficiary, and we have to run that asset through probate. But normally things like insurance, payable on death accounts, annuities, these are all having beneficiary designations. You're not going to see them come through the probate. And it's the same thing generally for revocable living trusts. Although I say that, and yet Shazam, earlier this week, we had someone turn a trust into us, and it had language that said, I leave all my assets to the following persons. See attached Exhibit 1. Nobody can find Exhibit 1. And ultimately, the trust is going to fail, and we're going to have to run all of that through probate, despite the steps they took to avoid it. Go ahead, Damon. And you can just double click through all these just to pull them all up. So this was just some of the terminology that I wanted agents to always be aware of. The person in charge of the estate is known as the personal representative. And sometimes we use the term, if there's a will, an executor for a male and an executrix for a female. If there is no will, then you'll hear it referred to as an administrator or an administratrix. If there's a will, the people that the assets are being distributed to are known as beneficiaries. But if the person dies without a will, what's called dying intestate, then the assets are going to go ultimately to heirs. And for our purposes, there's two types of administration. There's full administration and summary. And we'll generally use the agents to assist us on that, because the difference is that if the value of the estate, and I mean net value, meaning backing out any mortgages or liens of record or encumbrances, is more than $300,000, we do a full administration. If it's less than $300,000, we do what's called a summary. For the agents, it really is irrelevant, because either way, once I open the probate, we're able to go forward and have you list the property. Now, what's important is, and I always tell agents, make sure you're talking to the right party. In other words, it may turn out that a daughter of her mom, who recently passed away, is contacting you about the sale of the property, but it could turn out that there's a will and the daughter's not the person who's named or nominated as the personal representative. And so getting a listing contract signed by that person is pointless. So it's helpful to understand a little bit about this process and who the parties are that you should be dealing with. Go ahead, Damon. I always like to talk to the agents a little bit about timelines, because I know that I get agents who sometimes I've gotten every year, I probably get about a half dozen contacts where someone says, hey, Lee, we're actually in escrow and we've got a little bit of a problem. And what's that? It turns out that the person who owns the property is dead, and the person who signed on behalf of the seller hasn't opened up a probate. That's always a little embarrassing for the agent, to say the least. But we get a lot of situations where the agents get us involved, and they're just not familiar with the timelines. And I know that's frustrating for the agents. So I think it's important to understand that, first of all, you should not have anyone sign your listing contract until they actually get appointed as the personal representative, because they don't have authority to bind the estate. So what good is a contract if you've got someone without authority? The other thing is that if there are co-personal representatives, for example, if there's no will and the person appointed to be in charge of the estate will be known as the administrator, the Nevada statutes require that administrators have to be Nevada residents, or they associate with someone who is a Nevada resident. And so it's not uncommon in those types of situations that you're going to have co-administrators. You've got to have them both sign your contract. This is a little bit dated, because at the time we put this together, it was taking about a month to get a hearing. So from the time I file the petition, the clerk's office assigns a hearing date. I have no control over that. And right now, it's actually taking us closer to 6 weeks. It was taking us almost 2 months every time we filed a petition to get a hearing date. And then once I get that hearing date, then within 3 to 5 days, the clerk's office will actually send me a copy of the letters. So you've got to understand that from the time I get a hold of the client and file the petition, it's probably going to take about 7 weeks till I can get you a copy of what you need for your file to actually get them to sign, get this thing on the MLS and get it moving in the right direction. Go ahead, Damon. So when we sell a property, the first thing that you need to understand is that all sales of real property have to be submitted to the court for what they call confirmation. In other words, the court reviews this and says, do I think it's in the best interest of the estate to sell this property? And again, this indicates 30 days. Right now, it's taking us closer to 6 weeks. And that's important to understand because these probate sales are not for everybody. Of course, we've all had the buyer who contacts you and says, hey, I need to get closed on something real quickly. My furniture's in the truck, it's on the way, and I'm starting work shortly. Okay, great. Let me click my heels 3 times and make everything just go perfect. In probate sale, it just doesn't work that way. There's deadlines that there's no control that we have. So for the person that's looking for a quick close, that's generally not going to be a probate sale. What's interesting is that one of the most important things to understand about probate that's changed in light of COVID is that we are currently having no in-person hearings. And so these confirmation hearings, our Clark County Probate Court sits on Fridays, and it's the only day of the week they sit. And we used to have hearings, and when we would have a petition noticed up, I would be down there. I would tell the seller's agent to be down there and also provide that information to the buyer's agent, because what would happen is people can come into these hearings and they can overbid. And it's done just like a public auction. And so now that there are no hearings, we had an administrative order. And that administrative order has a section that specifically talks about probate. And it says that what happens is 72 hours prior to a confirmation hearing, there must be a notice of intent to overbid if you intend to bid. And so what happens is by Tuesday at 9 a.m., and there was some confusion about that also because agents have looked on the hearing dates and sometimes they see things posted at 3 a.m. I think that's just when the clerk's office may update certain records and they were thinking that that was the cutoff. It's not. The commissioners made it very clear that Tuesday at 9 a.m. is the cutoff. And so what happens is if no notice of intent to overbid is filed, then there isn't a hearing. That petition will just be automatically approved. And then we're generally getting an order no more than 2 to 3 days. We're submitting the order ahead of time, and the court's been really good about executing those orders and then getting them sent to us, usually no later than Monday or Tuesday of the following week. But if that notice of intent gets timely filed, what will happen is the court will assign, it uses a system called Blue Jeans, very similar to conceptually to Zoom. And so what happens is it sends a link to us and to the overbidder. And then we immediately make sure that the seller's agent, as well as the original buyer's agent, gets a copy of that link. Now, what happens is interesting because probate court starts Fridays at 9:30. About 9:15, the clerk will come on and start asking everyone to check in. We have lots of situations where someone files a notice of intent to overbid, and then somebody else comes in to overbid as well. And that's kind of an interesting issue because the order doesn't necessarily say that the notice of intent has to be filed for each person intending to file an overbid. So we've had this a couple of times where people have jumped in, and quite frankly, from the seller's perspective, what do we care? I mean, the more people that come in on an overbid, the better, because your commission goes up, our fees will go up, the seller's return goes up. But if nobody files the overbid, they just can't show up at that time, try and click on a link. There is no link. There is no link for that case. That case won't be assigned the link. Now, agents will call me, and I assure them, I'm going to get you the link as soon as I get it. The problem is, I generally don't get the link till about 3 or 4 o'clock on Thursday. So I know that puts everybody and makes people nervous, but I assure you, you're going to get the link as soon as we get it. And we've never missed anybody getting a link. But what'll happen is these overbids work that the court, for example, will say, okay, I have the estate of James Jones, and the real property being sold today is at 8572 Mockingbird Lane. The sale price is $250,000. The initial bid has to be $5,000 more, 5,000 more. So the judge will announce the sale price is 250, the upset price is 255. Do I have any bids? And then someone will just click on, this is Susie Smith, and we bid 255. All right, I have 255. Do I hear 256? Because normally what will happen is the commissioner will then take bids in $1,000 increments. It's been crazy. I mean, I recently had a client who contacted me from California. They sold their house in California. They said, you know what? Prices there are just so astronomical. We got like $1.6 million. We found, we're coming to Las Vegas. We found this really property in the Scotch 80s. It's not in great shape. We want to put a bid in. And so we actually represented them on the overbid. And that property that was appraised at like, I think it was appraised at like 730. The sale price was 700. I think they ended up bidding, and the original bidder got, or the original buyer got it for almost $900,000. It was just crazy. So what happens on the overbids, and someone just shot me a question, does the overbidder have to prove that they have the ability to produce the funds? And the answer is no. What happens on the overbid is if you win, you are bound by the terms of the original contract. In fact, what's interesting is I just had a case where two different cases where the overbidder won. And then this was last Friday, and on Monday, we got new residential purchase agreements where they tried to change the terms. They were trying to shift the real property transfer tax. They were trying to insert a new due diligence period. And the response was, no, it doesn't work that way. The statute is very specific. It says that what happens is that the order confirming the sale will show two differences to the original contract. One is the name of the overbidder, and two is the new sale price. All the original terms remain exactly the same. And in fact, the statute says that order becomes an addendum to the purchase contract. And we represented that to the agent. The agent was like, oh my God, I didn't know this. And didn't want to take my word for it, contacted the title company, and First American told him, no, Lee's exactly right. That's exactly the way it works. Now, if that buyer who won on the overbid does not perform and they're unable to close within the time frame, they don't get qualified for their loan, any of those circumstances, it doesn't matter. They are potentially at risk and can get sued if we put the property back on the market and it sells for less than what the overbidder bid. We can actually go after that buyer for the difference between those two amounts. So no, you don't have to, as an overbidder, produce a proof of funds, but it's no big surprise that 99.9% of the overbids are all cash investors because they're able to immediately perform. I had an interesting situation last week that arose where the seller's agent had been working with this buyer's agent, and the buyer really trying to get them qualified and get them into the property. This had been going back and forth for some period of time. And when the overbidders called and said, well, we're thinking of putting in a notice of intent to overbid, they said, well, we're not going to give you access to inspect the property. And I was like, well, that doesn't work, because the seller's agent, without realizing, was actually in breach of her fiduciary duty, which was to maximize the return on the sale of the property. And so it only took a couple phone calls to get that one straightened out. But these overbids can be a little tricky sometimes. And that's why it's worth talking to somebody to get advice of, really explaining to the client what the potential consequences are, because if something blows up, the first thing they're going to do is point their finger at the agent. One of the things to be aware about on these overbids is that the statute actually provides that a certified copy of the order is supposed to get recorded, and the title companies would insist on that. The problem is that because the clerk's office is working on a reduced COVID staff, where it used to take me 48 hours to get a certified copy, it's taking me 2 to 3 weeks. So most of the major title companies, in fact, even the ones that haven't initially, when we pressed them on this, they've agreed that they're going to take file stamped copies. And what file stamped means is when I get the order back, in the upper right-hand corner will actually be a stamp from the clerk's office showing that it was logged in and it's become part of the public record. And so it makes sense that the title companies are doing that now, rather than holding up, anywhere up to an extra month just to get a certified copy. Go ahead, Damon. So the petition to confirm, as I mentioned, is this public process. And it's really, there's an invitation for these overbids, and the minimum overbid is the $5,000. The reason it's so important for the seller's agent to be involved if there's an overbid is, quite frankly, help the attorney. There may be things going back and forth, bids coming in so quickly. I always like the seller's agent to be involved and know who, if there's an overbid, do they have to help me deal with to get this resolved. But the buyer's agent should always be there, unless the buyer just says, you know what, that's it. I'm not bidding on this anymore. I always tell the buyer's agent, though, I would still recommend be there and participate on the link, because we've had several situations where overbids have come in, or notice of intent to overbid. And then on the day of sale, what happened was that there may be 7 pieces of property. They're overbidding on 3 or 4 that go before us. And by the time ours come around, they've already bought other properties that they want, and they withdraw their notice of intent. So, for the short amount of time that this takes for the buyer to, the buyer's agent to be involved on the video link, it's worth it for them to just jump on the link so they can see exactly what's going on. Okay, next slide, please. One of the things that I always tell agents is be proactive. Do not assume that the attorney is necessarily looking out for you. And what I mean by that is review the petition. The petitions are required to have the commissions in there. Now, sometimes, it's possible the attorney or his or her paralegal make a mistake and they don't catch an addendum that changed the sale price, or they improperly stated what the commissions are. So I always tell agents, I think that you should insist on getting a copy of the petition. From the time that the petition gets filed to confirm the sale, don't forget that you're going to have about 6 weeks. I would review it right away. Make sure that everything's in there. If the attorney becomes defensive, then maybe you're dealing with the wrong person. But the fact is, those petitions are public record. And I would say be proactive and make sure that it accurately describes the property. The petition should have a APN and a legal description inserted in there. Attorneys, unfortunately, every once in a while, a mistake can get made. So look at the commissions, look at the address, look at the APN, look at the legal description, make sure the sales price is correct, make sure all the addendums got attached properly, because the last thing you want to have happen is a delay in that. If there is a mistake that doesn't get recognized until the time of the hearing, then it's a nightmare, because the commissioner may take the petition off and continue it, and it may get stuck have to roll over another 6 weeks. Or the real nightmare scenario is that the mistake doesn't get made until after it gets approved and escrow catches it. And then once again, there's a big delay and everybody's going to start pointing fingers, and the agents are the first ones they're going to complain about. I always think take the time to explain this process to your clients. Explain what an overbid is. Explain what could happen. You can't say what will happen, but it's important for them to understand, both the seller and the buyer, of how this confirmation plays out. But most importantly, one of the single most important things that I tell agents, and we have a class called 30 Ways to Lose Your License, and it's a 3-hour class. And the single most important thing that I ask agents to walk away with is understand the importance of the D word. And the D word doesn't mean disclose, it means document. This is the way that you as an agent can be proactive in protecting yourself. The buyer, for example, says, well, I didn't understand that if an overbid came in, I could lose the property. Well, with all due respect, you did. In fact, here's a copy of the email that I sent you confirming our conversation of the importance of letting me know if you want to attend and plan on overbidding. And again, being present at court hearing, if there is one, is important just so that you can monitor what's going on in that transaction. Go ahead, Damon. So from a seller's agent perspective, one of the things that we see every once in a while are discrepancies between the sales price and the appraised price. And I generally tell agents, look, don't get nervous about that. The property appraises at $350, but the best sale that came in was $325. Sometimes it's because the prices are moving in the wrong direction. Sometimes it's because of the condition of the property. I mean, we had a house that was after someone passed away, the family just let that one son stay in there. And so what happened was they just were not really communicating, and they let him stay in there. And so here we are, like a year after mom had passed away, and the son had turned it into a crack house. And it was just an absolute disaster. The family finally said, Lee, we just want to evict our brother. Let's take back the house and move on and handle, get a probate. And we did. And the appraiser doesn't go inside. And so he gives us one price, but the best sale price we get, there's about a $60,000 discrepancy. Well, and they had no money. They had no money to fix up and rehab the property. So it was being sold as is. We just had a contractor go in there and basically write up a bid. All the copper pipes had been taken out. The electric wasn't working. The rugs were in horrific shape. They hadn't maintained the house. It all had to be repainted. I mean, it was just a disaster. And sure enough, we got a bid for about $50,000 to $60,000 to everyone. $50,000 or $60,000 of the cost to repair and get the house in habitable condition. And we presented that to the court. Now that case was actually really interesting because a bunch of investors came in and there were about 30 overbids, and it actually ended up selling for the appraised price. But that's, those are the kinds of things that you don't get nervous about. We're clever about figuring out, well, how do we explain to the court why it's selling for what it is, and what would be a way of getting this addressed to show the court that it's still in the best interest of the estate to sell it at that price. Next slide, please. So other issues that agents need to be aware of is, first of all, disclosures in the MLS. I always think that right out of the box, you should be explaining in the comments section about the fact that this is a probate sale that is, 1, subject to court confirmation, and 2, possible overbid. And the reason is because buyers, they just think that the minute a seller has signed a contract, they have an enforceable contract. And that's just not the case. In fact, what's going to happen is you're going to submit a counteroffer. And the counteroffer will generally say exactly that. Number 1, this is subject to court confirmation and possible overbid. And the reason is because we're countering with seller's conditions. And every once in a while, I see the buyer, the buyer's agent actually does a pretty good job of putting some language in there, acknowledging that they're aware of that. I still like doing the counteroffer because it now forces the buyer to once again acknowledge that despite the fact that they've executed or they in their purchase agreement, they've acknowledged that there's a court confirmation. Now, once again, we're making it very specific of what their obligations are before they can be bound by this contract. And that is the court's got to find that it's appropriate and that nobody else submits an overbid. Now, one of the things that's really interesting about this is that personally, with our transactions, we also include a term that says that we will not file the petition for confirmation until the buyer executes a counteroffer executes an addendum acknowledging that all the buyer's conditions, including final loan approval, have actually been either satisfied or waived. Because what happens is these sales, here's the issue. If I file the petition to confirm and it gets confirmed, and then the buyer says, oh, sorry, I didn't get my final loan approval, and now they've rejected my loan and I can't perform, well, you got a problem. There's a conflict there because the buyer's going to rely upon the contract saying one of my conditions was being able to qualify and I didn't. But on the other hand, the statute makes it very clear that if you purchase a property and it's confirmed through probate, and we then have to put it back on the market, you potentially can get sued for the difference if we don't get as much money. And so this kind of use of an addendum makes it very clear that the buyer can't fall back on this, oh, I've got a condition that wasn't satisfied and I can get out of the contract. And when you explain these things to the clients, again, the most important thing is document, 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 because clients will have very selective memories of what transpired. And unfortunately, sometimes they really don't remember, but that's why just sending a confirming email is just so important. Go ahead, next slide, please. So explain the implications of a buyer's failure to complete. You know, it's important that the seller understand this, but it's not always the panacea that it sounds like, because if it goes on the market and there's, let's say, even if it's a $30,000 spread between what we sold it and what the overbidder had gotten it, the problem is, for me to sue someone over $30,000 may cost $50,000 to go chase them, and there's no guarantee that you definitely are going to get your attorney's fees. But they should at least understand that there's a possibility, and also explain to them the sales to the overbidders. You know that I had a situation just arise earlier this week where the family contacted me and said, well, we know that our grandfather really wanted to sell to this one person, a good friend of his. And I was like, look, that's a problem, because I can't control whether or not someone comes into overbid. And the property was in relatively good shape, and therefore we don't think that anybody's going to overbid. But it's important that they understand. Sometimes sellers get it locked in their head that this is the way that we're definitely going to settle this person, and that's not necessarily true. Go ahead, Damon. Next slide, please. So from the buyer's perspective, really, really important to explain the overbid process. I think more important for the buyer's agent to explain than the seller's agent, but because the buyer may lose the property. And one of the things that comes up from a buyer's perspective is, well, wait a second, you're telling me that I've incurred fees for an appraisal, I've incurred fees for a home inspection, and somebody else can come in and sweep this out from under me and I'm out all that money? The answer is, yeah, that's exactly what I'm telling you. And so one of the things that I always encourage buyer's agents to think about is, if it's a probate sale, why not include a term that in the event we lose the property in an overbid, that we will get reimbursed the cost of the appraisal and the cost of the home inspection? I mean, is it really that big of a deal to the seller? He's got to get at least $5,000 more on the overbid because that's the minimum amount. So if he has to come out 5,000 to 1,000, I'm sorry, 500 to $1,000, hey, there's still $4,000 ahead. So it makes a lot of sense to think about that if your buyer starts to get a little concerned about the overbid process. One of the areas I really see agents get in trouble is the buyer who says, well, I can't be there. I'm going to give you written authority to bid on my behalf. I can hear brokers right now falling out of their chairs because that is, that's potentially a problem. It used to be more of a concern and more common when the bottom line was when we only had hearings and the person was like, well, I'm out of town. Well, now that they can jump on a link, it isn't that much of an issue, but I think it still happens. And if you're going to have written authority, absolutely run it by the broker. Make sure they're comfortable with it and they sign off on it. Again, importance of documenting communications, really, really a big deal. Because that may be the best way that you give me the ammunition to protect you. And that includes explaining to them what happens if you fail to complete the transaction. Now, one of the issues that I find that surprises me that agents don't know about is that, and this isn't a new law, this has been around for a long time, which is if you're the original buyer's agent and you lose on the overbid, you get to split the buyer's side of the commission. You get one half and the overbidder's agent gets one half. So, you know, that's a nice little thing to know about. And all the more reason that as a buyer's agent, you definitely want to be involved in the transaction to see what happens with the overbid and then nicely remind the seller's agent, oh, by the way, that language should be in there in your order. Next slide, please. So one of the biggest issues that comes up on these probate sales deals with the seller's real property disclosure form. And everybody knows the general rule. And I'm not talking about the agent, I'm sorry, the seller's responsibility under the disclosure form. What really is the serious problem for us is the agent's duty to disclose. Under 113, though, the seller's real property disclosure form, the general rule is that it has to be completed by the personal representatives. There is no, excuse me, there is no waiver. In other words, right now, there is the State Bar of Nevada probate section is actually submitting to the legislature consideration a change to NRS 113 when it comes to sales and probate. And when you think about it, it makes a lot of sense because the people who are signing the SRPD form, they've never generally lived in the house. They have no idea about the condition of the house. And those documents are completely unreliable. And as a buyer's agent, you ought to be absolutely explaining that. And as a seller's agent, you ought to be making sure that there's some additional language that points that out to the buyer. So the bottom line is that for licensees, I think that you got to be aware of these disclosure issues and make sure that you're being proactive in explaining, look, we really shouldn't be relying upon the SRPD. I'm not suggesting that someone's filling it out and fabricating anything or hiding anything, but they just don't have personal knowledge of the property. And therefore, maybe there's some extra things that we should be asking for as a buyer's agent. For example, was there, since the probate was opened, were there any repairs done to the house? Was there any rehab that was done? Can we get copies of those documents to verify that? I think that's really important that you look at those types of issues. Can I get the next slide, please?
Yeah, and team, I just put the exemptions in the chat box just so you know for SRPD.
So the issues for the agent relate to the discovery of the property. And I think that, under 645-252, an agent has to disclose what they knew about or through the exercise of reasonable care they should have known about. So the record request is a great way to, first of all, try and identify that. But one of the greatest sources that I think exist are the neighbors. Neighbors love to rat out other neighbors, especially who are never coming back to life and going to confront them about, behaviors that were going on in there. Maybe they were growing marijuana in the house. Maybe, there were water leaks in the neighborhood, mold issues. It's a great way of trying to find out about a house. The common interest community documents. A lot of times agents get those, and I don't think that they read some of the things that might tip us off. For example, if we're able to get minutes under old business, you may see not just existing lawsuits in those disclosures, but in the minutes you may find threatened lawsuits and things that would tip us off about problems. But one of the interesting issues that come up in the probate sales from time to time are the cause of death disclosures. And what I mean by that is the statute is very clear that we do not have an obligation to disclose if someone has died in the property. And even though it's a probate sale, it's interesting to me how rarely those kinds of inquiries come up. But we know that certain ethnicities will definitely make those inquiries. So for example, Asians much more than Caucasians, it's not just the feng shui of the positioning of the house, but they'll ask about the history of the home. And so the question is it appropriate and are you permitted to disclose a death in the property? And the answer is you are, but I still think that you treat it as confidential, because you can disclose confidential information if you get the consent of the seller and you do so in writing. That's how you protect yourself. And so I've had a number of these cases, and the perfect example was we had a case many years ago involving a gentleman by the name of Bill Rundle. And if you've been in Vegas for a long time, you may have actually remembered the Rundle case because Dateline did a huge expose on this. And Bill murdered his wife, Shirley, inside the house, dragged her body through the house, loaded her up in the car, in the trunk, drove to California, rolled her body out into the desert, and then disappeared. And they tracked him down to, they tracked him through his credit cards to Florida, and he was extradited, and he came back, and they put him on trial. And of course, he didn't enter into a plea arrangement. The case went to trial, and then shortly before the jury went out to deliberate, he actually entered a plea agreement and got life without the possibility of parole, as opposed to the death sentence. And so here was this house that was owned by Bill and his wife, Shirley. And we have a statute in Nevada that says that if someone conducts a wrongdoing, they can't benefit by that. So he was not going to be the sole owner of the house, but now I've got it owned by the murderer as well as the estate of the victim. And so I had to go to prison and meet with Bill and his attorney. And actually, he was pretty easy to work with. He signed over the whole house to us. And now the issue became, when we list that house, what do we do? Technically, we didn't have to indicate that someone had been killed in the house. But the best way I explained it to the victim's daughters, I said, look, here's the nightmare scenario. We sell the house and we don't disclose it. And we sell the house to this very nice couple, Mary and James Jones, and they move into the house. A week later, it's little Jimmy Jr.'s birthday, and it's his 6th birthday. And they meet the neighbors and they invite the neighbors over. And during the course of the party, one of the neighbors says to little Jimmy's mom, hey, does it ever bother you that little Jimmy is in the room where the previous owner was murdered? The problem is that once we use the smelling salts and we get little Jimmy's mom up off the ground, she's going to get extremely upset, and she's going to point the finger, and she is going to carry on and file a complaint. Ultimately, we win that lawsuit, and we even win an ethics complaint. But why have those kinds of headaches? I will tell you, in that case, we disclosed it. People were concerned about the stigma, and we actually have a brand new one credit class that we just got approved by the real estate division about stigma and houses associated with death and hauntings and other issues. And what we find is that over the long haul, stigma disappears and doesn't affect the value of the property. Yes, we had some people that came out from underneath their rocks and tried to steal the property, but the family held firm, and ultimately we sold that property for fair market value. We've had several homes associated with deaths in the home. One actually with an attorney that I knew here in town that I went to law school with, and he committed suicide and hung himself in the garage. And we handled the estate for his brother, and the question was, do we disclose? And the answer was, yeah, absolutely. And again, we were able to sell these homes for fair market value. So I think the bottom line is that if you get a cause of death inquiry, the bottom line is you got to be honest. I think you deal with it head on, and you make the disclosure even before an inquiry is made, because it's going to come up at some point down the road, and you're going to be getting these frantic phone calls. Anyway, next slide, please. So I'm just wanted to point out that we've got a number of resources that you can take a look at. One of them, we have several ebooks. One of them is on probate, and all you have to do is go onto our website, and you can download that at no cost. And it kind of gives you the big picture view of what probate is and how that works. And so I just wanted, Damon, if we have a little bit of time, I saw a bunch of questions come in. I just wanted to kind of roll through those and see if I can answer a couple.
Please, yeah, if you have your eyes on them, go ahead.
Okay. Let me see. Do we have a chart that shows the timelines? No, but the bottom line is 6 weeks. That's the only thing you need to know, is it's generally taking me 6 weeks to open the estate. And then from the time that I file the petition to confirm, it's taking another 6 weeks to get that hearing date. That is a pretty accurate assessment of the timelines that we're dealing with right now. I have 2 probate listings right now. We had overbidders, investors try to change title companies. I have, like I say, we've just had 2 situations where not only did they try and, there were a lot of things they tried to change. They tried to shift the responsibility for the real property transfer tax. They tried to shift the cost of the title insurance. But the one that really concerned me was they tried to open up a new due diligence period. And we were like, no, it doesn't work that way. The statute's very specific that the way this works is the contract, the original contract is what's getting confirmed with only 2 changes, the name of the buyer and the sales price. Now, does that mean hold firm on every single issue? I don't know. I mean, if for some reason using another title company facilitates this to go faster, I'm not sure I see the problem with that, but there could be a lot of reasons that you may necessarily want to hold firm on the title company.
So Lee, one of the questions was, so if the buyer uses one of their outs, right? One of the terms of the contracts to get outs, right? Do they still have any damage?
Well, this is an interesting question, because it's from the way I do it, the answer is no, they can't, because I will not file the petition to confirm until they sign this addendum saying that they've waived all those outs.
Okay.
But
So
not
that,
all
like,
attorneys do it that way, and it raises some really difficult questions. Now, the only time that we really ran into an issue is during the beginning of the pandemic. NER came out with the COVID addendum, which I hate. I think it was not well written. I know that nationally, associations across the country adopted this, but the problem we were running into was the COVID addendum was really for a person who they got their loan approval. We entered into the contract, and then what happens? They get laid off by the hotel, and now they can't get funded. We understand in those kinds of situations, but what we were finding was investors were buying properties, and then they were using the COVID addendum saying, you know what, we don't think we're going to be able to rent this house out. It's not economical for us anymore. Oh, but if you give us a $50,000 price reduction, we would consider still doing the deal. And my response to that was, you know what, go pound sand. And every one of my clients held firm. We just told them, take your money back, take your earnest money. We went on and we still sold the properties for fair market value. So that happened about a half dozen times, like last March, April, May, but we haven't seen that come up recently. So anyway, getting back to that question about the buyers trying to get out, it's a tough one. But if the transaction's handled properly by the attorney, that should never be an issue. Somebody asked about, can we see what probate cases are coming up each Friday? Yes. What happens is if you type in Clark County Probate Court, the website comes up, and then there is a tab to see the preliminary rulings. In other words, the commissioner will publish what cases are coming up and what his rulings are on most of the cases. On most of the cases. On the sales, he just puts sale. But what will happen is you'll see all those cases, and then it's public record. You can look it up and see, oh, okay, here's the petition that they filed, and this is what they're selling. And then you've got to hustle to see, is this a property that you want to have someone bid on? But normally you'll only get about a 5-day window. Subsection 1 does not apply to a sale of intended sale of residential property by foreclosure.
Yeah, I just threw those in there just for the age. That's NRS 113-130, the 4 exemptions.
Unfortunately, none of those have an exemption for a
Correct.
sale through
Correct.
probate. And that's one of the things that I mentioned that they're working on. So are you saying if a buyer uses one of the outs in the contract and the house sells for less, the buyer might get sued for the difference? That's exactly what I'm saying. That's exactly what I'm saying. And that's why the way we structure the transaction, it's impossible for the buyer to use one of those outs. It doesn't mean they don't try. One of the issues that we've come up with, that we've seen come up is, and this just happened again, just 2 days ago, from a transaction last Friday, the guy got the property overbid and the original buyer put money into the property to make certain repairs. And he put the money in to make those repairs on the basis that if they weren't there, his mortgage he wouldn't have qualified. The underwriter wouldn't approve the loan. Well, the problem is that nobody bothered to address that in the contract, and he lost the property and is now asking about, well, how do I get my money back? And the overbidder's saying, not for me, you don't. That's your problem. And now we're in a really weird situation that he may end up having to sue the estate to try and get reimbursed under some kind of equitable claim. Really, I feel bad for that buyer, but it was a huge risk. And I'm less than convinced that his or her agent explained to him that the possibility that if you lose the property, it's not going to be so easy to get reimbursed.
Lee, we're at the top of the hour, so I don't want to rush you here, but a couple of additional questions I think
Sure.
Agents, important to the agents are, what happens to the commission on an overbid, right? So I know the answer, but want to hear it from you as far as, hey, I got my buyer property, somebody overbid, right? So I lose that sale. What happens to my commission?
The bottom line is, as I just mentioned a little bit ago, you get to split the buyer side of the transaction.
Wonderful. So you guys split the buyer side commission. So let me ask you, is it possible to put my contingencies after the confirmation of the court of approval for the sale?
I'm not sure I understand that question.
So can I put buyer's contingency periods to start after property goes through court approval?
Well, let me put it this way. You can try that. You're never going to get it past me. I mean,
okay.
I would never do it because, but we just had that happen. In fact, I had an agent who we were working with on a transaction. They submitted a document to me, and we're very sensitive to the fact that, look, we know you need an answer right away. But what happened was they sent it to me like 3 o'clock in the afternoon. I wasn't able to get back to them till the next day. They just, without me reviewing it, went ahead and had the seller sign off as well as the buyer. And that's what they did. They had the contingencies starting after the confirmation. And I called the broker up and said, I just can't believe you guys did this. Because unfortunately, if this blows up, I'm going to end up having to tell the client that they need to assert the claim against you, the broker. And ultimately, the broker was able to work it out and get that removed and revised through an addendum.
Awesome. Is there any, you guys, there's a couple other questions. I know we're at the top of the hour, folks. This was actually really great information. And, I wanted to get probate in front of you folks just because with the shortage of inventory, this, as you heard Lee say, that there's a lot more people overbidding, right? They're looking at this as a vehicle or an avenue to find a property. And so it's pretty important for you guys to know, not only on the buyer side, but also possibly as I believe, baby boomers hold on to about 75% of real estate holdings nationally. There's probably going to be more probates, right, Lee? I mean, what's your estimate?
I mean, what we're seeing, you hit the nail right on the head, Damon. We've got all the people that are coming here as retirees. We've got the baby boomer generation that's getting older. And I mean, despite the pandemic, quite frankly, our probate sales have been booming. I mean, we probably have about over 100 open probates right now, and probably 30 to 40 probate sales just right now. So there's a lot of activity going on, and it's a great opportunity for agents. But you got to, quite frankly, you don't have to be a probate expert. You just got to use your common sense. And in most of those cases, I find that agents get themselves in trouble. It's because they're just ignoring that little voice in the back of their head that says, slow down, use your common sense. Something doesn't pass the sniff test, but let's just go ahead and do it anyway. It'll all work out in the end. That's what gets agents in trouble.
Yeah. And so as far as earnest money goes, that's going to be returned to the buyer. I think that's a no-brainer, right? If there's an overbidder, the original buyer gets their EMD back.
Correct.
Right. So as an agent, how do I get a list of people that are possibly probate? How do I find probate sellers? Any recommendations, avenues for that?
Yeah, one of the things that you can do, again, is you can go on to the list on the probate court website. You just type in Clark County Probate Court, and you'll see that there's a list, and that you'll click on that link, and it'll show you the preliminary rulings. And so what it will show you is the cases that are being opened, but it also show you all the cases where there are sales that are pending. That your buyer can go overbid. Correct.
Right. So awesome. No, it's nothing new about splitting commission. I think it's been like that for quite some time if you lose on overbid.
That's correct.
Right? Yeah. So any other questions, folks? Otherwise, I want to be respectful of your guys' time as well as Lee's time. This was actually, I appreciate it, Lee, because you actually went over a little bit more than I thought, which is great because this is a big part of our market right now. I believe it is, and agents need to make sure they have it on the radar. So you guys, of course, you have Lee, get on his website, get his books, read up on it. But more than anything, you guys also, if you don't subscribe, he emails out different classes that he does, throughout the, the months. And, it's always great to have somebody come into our meetings that knows what they're talking about. Sometimes we have a train wreck, and it's always good to know Lee's, he's on top of everything, and that's great. So I truly appreciate that.
Absolutely. In fact, and I appreciate you mentioned that, Damon. If there are agents that are not on our email list, just shoot me an email. I mean, we do post on LinkedIn, and if you've linked in with me, the only problem is that sometimes if you're not on at the right time, you're going to miss a post. But if you go ahead and shoot me an email, we'll make sure that we get you on one of our lists, that you'll be sure to get all of our emails about the real estate related topics.
Hey, and you guys, we're going to let Lee get moving on. Charity, I believe, is still on here, and I wanted to make sure that she had any real quick updates. I know you guys are probably chiming out to get on with your day, but Charity, if you're still with us, would love to hear.
Yep.
Just kind of, I know things are changing with rates right now a little bit. So a real quick update on that. And again, thank you to Lee for all the wealth of information on probates.
Thank you, Lee. Can you guys hear me?
Yep. You're
Okay.
Good.
So real quick, I mean, that's actually all I was really going to cover today. So pretty much we're having just a lot of talks this week. The Fed is testifying today, and they did testify yesterday. And we have a ton of reports. Tomorrow we have jobless claims, initial ones and continuing ones. We have new home sales, durable goods, pending home sales. So we just have a lot of information. So we saw last week and this week a huge jump in rates. And so we had a lot of people freaking out. And then yesterday, so it was just alert to locks, 2 or 3 times a day. However, we are seeing a little bit of that. We're seeing a little bit of that kind of calm down now. So ahead of any time when the Fed is going to testify or speak, a lot of investors will kind of jump the gun and increase their rates, because it does get everybody to flurry to lock. And then depending on what the Fed say, they can either increase it again, right? And then they're ahead of that curve, or they can drop it back down, and then everybody, can breathe again. So we did see yesterday, we got at the end of the day, after we had a rocky morning, we had a little bit in the afternoon where we got that alert to float, which means, okay, we're kind of rebounding. The Fed, as he was testifying yesterday, is acknowledging that we're still in the middle of a pandemic. And although we are seeing some growth in some sectors, obviously as a whole, we are not seeing that growth all the way. He was testifying again at 10 a.m. I'm assuming that's, Eastern time. So I'm sure that they'll be wrapping up that talk in the next couple of weeks, but we still have a lot of big reports tomorrow and Friday. So today we're at breathe a little bit. And now when I did say rates went up, we're looking at 3 1/8, 3 1/4. So it's not like we're at 5%. 3 1/8 and 3 1/4 is still an amazing rate. But when you see 2.7, 2.8, and then it goes to 3 1/4, we all get a little nervous. So that was kind of, just what I wanted to go over is, yes, we're going to have a lot of big news this week. We saw a lot of craziness last week, so I hope that we should kind of level out this and see some,
Yeah, so let's do this, Jay. We'll bring you on again next week.
Yes.
Right? Since all this is happening right now, let's get you on next week, and we'll give you more time. Obviously,
Perfect.
We'll share just what's coming down, the pipe, and educate the agents. And so we appreciate you definitely for hanging out with our meeting today. I apologize.
No, super informative.
Lee was able to get in and get the information out to the agents. We'll be sending all this stuff out. If you guys aren't looking at the weekly newsletter, we're really doing our best. If you guys didn't watch my video, you guys got to watch my videos. I mean, come on, it's a no-brainer, right?
Amazing, right?
Anytime, kidding. But anyways, really trying to make sure the newsletter has the things that you guys want in it. So if you guys have any recommendations for that as well, you're probably going to have, you'll get some information from Charity to put in that newsletter as well. But you guys, respect your time. Thanks for hanging out a little bit over this week. We'll see you guys for our next week meeting. We got a full lineup coming for you guys. Some really great speakers. Myself and Tim have been working on some good stuff to just make sure we have relevant information in front of you. We'll have Charity back next week to give updates on all this good stuff. So you guys go out and make it an amazing week. Make sure you're looking for all opportunities for listing inventory. Today was a huge topic on probates. which is a great vehicle to increase your listing inventory if you're not already doing so. So you guys make it great. We'll talk to you soon. We're here if you need us. Thanks again, Charity. All right, guys.
Bye.